Controversies trailing both the trial of Yoruba Nation agitator Sunday Igboho and IPOB leader Nnamdi Kanu has put Nigeria in the spotlight. The role the executive and judiciary have played in both cases has attracted criticisms and unanswered questions. Currently, you would agree that the Nigerian judiciary is on trial, with the Attorney General of the Federation, Minister of Justice and Justice Nyako at the front burner. Seeking a legal perspective to some pertinent questions, we spoke to Barrister Charles Ifezue, a past NBA executive, and Barrister Mike Umonna, who spoke extensively on the judiciary standing trial.
When you say Nigerian judiciary is on trial, I want to believe that you mean that Nigerian judiciary is in the eyes of the public as to how the proceedings relating to the Supreme Leader of the IPOB, Nnamdi Kanu, has been handled. But I think that is just one of the things that has happened in the past few months that would actually make the judiciary to be on trial. This same judiciary was on strike for about 3 months in Nigeria. The whole courts shut down, and nothing happened. So that shows you the kind of system that we are. Judiciary is just one of the arms, the 3 arms of government in Nigeria. Whatever challenges that they are facing is a reflection of the challenges that Nigeria as an entity is facing. But I will just come back to your own question and not make it seem as though the Nnamdi Kanu's trial is what is putting Nigerian judiciary in the eye of the storm. I haven't really followed the proceedings as a lawyer. Most of the information that I have gotten about it are information that we get from the media. So that I would be circumspect in analyzing any situation based on those information. But there are certain things that are public knowledge, one of which is that Nnamdi Kanu was, picked up, whether you call it arrested, kidnapped, whatever it is, from another country, and I hear it is Kenya, and he was brought back to Nigeria to continue to face a trial that he was facing before he was granted bail some time ago. And that trial has recommenced, as it were. And if you ask me of my opinion, I think there is nothing wrong with Nigerian, the judiciary continuing with the trial. What I think everybody has their eyes on is the possibility of the judicial system being compromised, particularly because of some of the things that happened between the time that Nnamdi Kanu was granted bail and the time he was rearrested. It is possible for, and I hope that doesn't happen really, it is possible for anybody who is the judex in that matter to become sentimental. Those have not happened yet. I don't believe that any of those have happened, but those are possibilities because of, some of these events that I've talked about between the time of bail and now. So I think everybody's eyes are on the ball for Nnamdi Kanu and whoever else is facing similar challenge or similar trial to ensure that the judicial system is not compromised.
Very well. The Nigerian judiciary, as we know, has been influenced by the political class. And it's rather unfortunate that we no longer have the kind of fearless judges or justices that we used to have in the past. We have few of them that are there, but they are also afraid of their lives. The few ones that are fearless are afraid of one thing or the other, which makes them not to be fearless, as it should be put. This issue of Nnamdi Kanu is a very delicate issue. And it is important for the Nigerian judiciary to know that it is even the judiciary that is under test, under focus now. Because the law does not permit secret trial of any form whatsoever. The law says that every criminal trial must be in the open courts, open to all the public, to anybody that is interested in. The restriction can as well, because of security issues, can be to a certain number of people. Not that you are going to make it secret trial, keeping away the journalists and telling them sometimes you now have to accredit some journalists and say that you pick those ones that would not say things that would have to abide by your censorship of what they are to write or to air. It's wrong. Very, very wrong. So what my advice would be to the judiciary as it is now is that the world is watching. And since this Nnamdi Kanu's case is very delicate, they should be very careful in doing things that the international community will see as being retrogressive, things that the international community will see as jeoparding, a jeopardy or something that is infringing on the rights of Nigerians, apart from Nnamdi Kanu. We all know that Nnamdi Kanu is actually agitating for self-determination, which is allowed in the international law. Under international law, you are allowed to agitate for self-determination. The only thing that you are not allowed is violence. Violence. It is only if it is traceable, any violence is traceable to Nnamdi Kanu, that he can be charged for those treasonable offenses that they have couched. But as it is, this man has been saying what they want is a Biafran, a country called Biafra. And they are entitled to it, provided they don't go with violence. And every Nigerian, any proper Nigerian would know that IPOB is not actually violent.
They also looked at prolonged detention of Nnamdi Kanu in DSS custody and the position of the law in such matter. Protest is a right enshrined by the Constitution and international law. Reacting to the order by the Attorney General of the Federation, Abubakar Malami, prohibiting the presence of IPOB members in court ahead of Nnamdi Kanu's trial was also clarified by the lawyers.
So I would, if you are asking about the regular process from investigation at the police station and then to arraignment, I would say that the Constitution says that anybody who is suspected of any criminal act should be taken to the nearby court within 24 hours and 48 hours if there is no near court, as it were. So, yes, 24 hours. But this one is a different situation. This is because he has been taken to court. There is a charge already. The court, in its decision, in its own wisdom, remanded him. Later, bail was granted with some terribly onerous conditions. And at the end of the day, Mr. Nnamdi Kanu was able to meet the conditions of the bail, and he was released on bail. Well, the fact that the judiciary is under siege does not mean that there are no judges who are upright, who are independent, who will do their work without fear or favor. There are. And I mean, even as young as we are in the practice, we have seen some of them living dead, retired, and serving. So I don't want to presume that because the executive has shown so much of appearance on the judiciary, that the case of Nnamdi Kanu is a foregone conclusion. No. I want to believe that the judges, I don't even know the name of the judges involved in the matter, but I want to believe that the oath of office that every judge takes is important to him, is paramount. And there are judges in Nigeria who will not succumb or bow to any intimidation by anybody. And I want to hope that the one involved in this matter is one of those.
I want to take a look at the one involved in this matter. She is Nnamdi, and her husband is an APC member in the House of Senate, I think House of Representatives. Looking at that affiliation, do you see anything fishy?
No. Okay. So the fact that someone's husband is a politician or a senator or anything does not mean that that person is going to be compromised or biased against a particular person. Judicial system is one that is done in open. Parties are allowed to be in court in normal circumstances. The pressmen are allowed to be in court. So a judge knows that when he's on trial, when he's sitting as a judge, he also is on trial by the public. So that is always paramount. And the oath of office that every judge takes is one that is very important to them and must be kept as sacred as possible. I know that if the defense counsel thinks that there is any likelihood of bias, there is also a procedure under our law to ask for the judge to be changed. And if you have facts that will establish that, I'm sure that there are other judges in Nigeria who would also do the matter. So I don't think that the fact that the husband to the judge, like you said, is a politician is actually a foregone conclusion that the judge herself will be biased towards anybody. So there are two, I said this everywhere, there are two rights that are fundamental, the powers that the populace, the average citizen has. One is the power of his vote to elect who becomes his representative. The second one is the power of protest. Those two cannot be taken away from anybody. I understand, yes, that the Constitution makes provision for, infraction of the rights of citizens in the case of public safety and all that. But there are decisions of the Supreme Court that rights to protest is one that must be preserved by the police themselves. So you do not need any approval of anybody, whether the police, whether the AG, whether the president, to protest under the law. But you must ensure that your protest is peaceful and ensure that it doesn't degenerate into crisis. Once that doesn't happen, the Attorney General, who himself is a senior advocate, who ought to know in a sane climb that you do not need his approval to engage in protest, should not be the one making such statement that you said he has made. He shouldn't be the one to be making that. The right to protest is one that is inalienable. Every Nigerian has the right to protest peacefully. And that's what the law says, and that's what the Supreme Court has confirmed.
Okay. My last question. The defense counsel to Nnamdi Kanu, therefore, he said something. He said that Nigeria does not have a legal status in trying Nnamdi Kanu because of the reports that he was abducted. The reports that he was abducted in Kenya. A kidnapper does not have the right to assume any legal status in trying. I don't know. Just help me out.
But that's his opinion. Like I said, he is the one involved in the matter. So if he strongly believes that his client was abducted or kidnapped, then and he thinks that there are legal provisions which says that a kidnapper cannot be a prosecutor, he can export those in the courts. And I think it's important that we put those issues in perspective.
The truth of the matter is that we have the right to protest, but the government will always want to ensure that these protesters don't go violence. And that is why they try to stop them from protesting. A right to protest is an international right that cannot be circumspected. You have to allow an individual to protest within the ambit of the law. But the moment you try to suppress protest, you are in essence trying to build up anger and agitation that will move to a different dimension that you might not be able to contain. And that is why the international law allows peaceful protests over any issue. And those people that came to protest, I did not see any violence. They simply exercised their right, their fundamental right to protest under the Nigerian constitution, right to protest under international laws and conventions. So I do not see anything that was wrong. But the police, the Nigerian state, as it were, is interested in suppressing every form of expression of anger over their conduct. And it is very dangerous for the system, because what we are doing is that the moment you push an individual to the wall, it will bounce back. And that will be very dangerous. Nigerian state should handle the issue of this agitation very carefully, and as sensitive as it is, the Nigerian executive in particular should know that if this issue is not handled properly, we are going to set the ball rolling into escalating into a situation that we have the kind of violence that we might not be able to contain. And that is what we are praying against. We don't want a situation that something will happen that will make us to start running helter-skelters from our houses. And there is no politician that will be saved if anything happens to that extent. There's no policeman, there's no security man that will be saved. There is an extent that the people just revolt, and you discover that your gun can do nothing. Your machine gun or all the ammunition you have will not be able to serve the situation. So it is important, now that it is good enough time to look for a way to solve this problem, it is important for the Nigerian state to know how to handle the situation so that it does not snowball into something else that the state might not be able to handle.
Okay, looking at the purported illegal detention of Nnamdi Kanu by DSS,
Yes.
What is the position of the law when we talk about detention?
You see, once you have committed a crime, the police has a right to detain you. You know, the issue of Nnamdi Kanu is different because he was already before the court. He jumped bail, of course, and then how they brought him back is a different issue completely. But once he is supposed to be before the court, the police is, as a matter of duty, expected to produce him in court. A criminal trial cannot go on in the absence of the defendant or the suspect, whatever name you want to call. It cannot go on. There are so many decided authorities that no defendant can be tried in absentia. You can't. It is not done. So, since the DSS has custody of Nnamdi Kanu, DSS is expected to produce him. And I'm glad that the court actually gave that order that on the next adjourned date, he must be produced in court. He has to be produced in court. The information I'm having is that probably they anticipated yes. So that was why they kept him away from the court. But they should be able to handle the situation very well. If they know what to do, 2019, when they decided to go after the justices of the Supreme Court and some judges, we knew that they were trying to intimidate the judiciary into subjugation, so that whatsoever they will say, the judges will do for them. And unfortunately, we still have some judges or justices that will not succumb to whatever intimidation they bring. But it is obvious that the judiciary is under siege by the executive. The judiciary is under siege by this present executive. The executive has done virtually everything possible to ensure that every judge, every justice sings or dances to their tune. And that is not good for the independence of the judiciary. So what we should expect is that, and unfortunately we saw how the CJN came on board. And by reason of his appointment, it becomes difficult for him to fight his appointer. It's difficult to fight your appointer because by reason of the law, the legal arrangement, the way they removed the former CJN was wrong. And so this CJN shouldn't have been brought in the first place. The way the judiciary has been going on in the past, there is no judge or justice of the Supreme Court who would have agreed to become the next CJN by reason of removal of that CJN. Because it was wrong. It was illegal. But this CJN decided to come in and become the CJN. It becomes difficult for this CJN to be able to fight the executive.